My name is Hannah Williams. I'm joined by Amy Delamarter. Together, we are the sales team here at Western Title and Escrow. We've received a lot of questions lately about probate. We've been seeing more probate in our transactions, so we thought it'd be a great time to put this class together for you. We have two presenters today, our very own Arianna Lease. Arianna is an escrow officer here at Western Title. She has over 20 years of experience, a very high volume desk, so she has truly seen it all. She's been dealing with a lot of probate as well, so she has a lot of experience and knowledge behind it. She's partnered with Matthew Matrisciano, who is a local attorney here in Bend. He also has history with working with probate. So together, they have put together a great class for you guys. Again, please utilize the Q&A box. And Arianna, Matthew, I'll let you take it from here.
Thank you, Hannah. Good morning, everybody. Just to kind of take from what Hannah has said and reiterate it, probate is a pretty robust topic. We only have a very limited amount of time, so all that I ask is that any questions that you do put into the Q&A, please keep them to a very generalized topic, because what happens is more circumstantial questions will bring us down a rabbit hole and can certainly distract us from kind of the topic at hand. With that being said, any circumstantial topics, please feel free to reach out to Matthew directly after this class. He will be providing all his contact info, and you can definitely set up a private consultation with Matthew. Matthew and I actually have quite a long history together, as some of the people that work with me currently, some of the agents that currently use us for title and escrow services, you will know that Matthew Matrisciano is an attorney that I refer out for all estate purposes. That includes trust, that includes probate, small estate probates. I refer him to all clients. We have a great relationship. I highly regard him and his education and his knowledge. And he's always readily available. So I'm really excited that Matthew can join us today. And I know that he is going to be providing with us quite a bit of information that I think will definitely help you and your clients in the future with, different life changes that always seem to pop up at the last minute when you least expect them. So thank you so much. Matthew, go ahead.
Thank you, Arianna, for that introduction, and I'm definitely happy to have earned your trust. I am an attorney, like Arianna said, here in Bend. I specialize in estate planning, probate, special needs planning, and long-term care planning. I've put together this presentation to kind of give an overview. It is Probate 101. It is probate is very nuanced, and everything here should be taken with a grain of salt because there are often exceptions, but this is to provide you with a basic knowledge to know, what's the best way to move forward, what's some information that I can provide to the client that might actually add value, and help your relationship with them ultimately. So I'm going to do a share screen. I have some slides prepared and we will get started. And can you confirm that went through? Okay, awesome. So this is me, my law firm, and my contact information. At the question and answer section, I'll have contact information again there too for both myself and Arianna. Some topics we'll cover today include probate options, probate alternatives, a quote unquote normal probate, which I say that in quotes because they are really all different. Small estate affidavits, transfer on death deeds, joint tenants with right of survivorship, and so we'll just kind of get going through those. Some alternatives to probate. I'll talk to you about small estate affidavits a little bit more later in detail, but those are only available if the real estate is worth less than 200,000 and all other property is worth less than 75,000. And like I said, we'll kind of get into the details later there. There are still some properties that I'm seeing, where this works. And we'll talk about whether you should do it, and some of the pluses and minuses of doing that. Transfer on death deeds. I have a slide on specifically on that later. Joint with rights of survivorship. And we'll talk more about that later too. Essentially, that is either a bank account or a piece of real estate. If there is an asset where there are joint owners with rights of survivorship, then one of them dies, then the survivor owns that asset outright after that first death. And that does not require probate. It just goes directly to that person. And that is very different from other forms of joint ownership, like tenants in common, where they have separate interests in that. So if, a piece of property is owned by Matthew and Arianna as tenants in common, and then I die, then Arianna would have 1/2 ownership, 50%, and my half would pass through my estate plan and possibly probate. We'll talk more about that in some detail later. Life estates are something that for some reason I'm seeing more and more of, and I wanted to touch on it briefly here because you might run across it. A life estate is something where a deed might say to Arianna for her life, and then to Matthew Matrisciano. And in that situation, if Arianna has, during her life, has full rights to use of that property, and can do, in theory, anything that she wants to with that property. But if she wanted to sell that property, she would only be selling her life estate. And so in order to sell the property as a whole, I would also have to agree to it and sign as the remainder beneficiary, because then you're capturing the entire fee simple, the entire ownership right in that property. So life estates, I do see them. It's kind of a sometimes a do-it-yourself plan that some people put together in maybe decades ago or sometimes recently. And so you just need to be careful about what it owns. A revocable living trust will avoid probate for any asset that is owned by the trust. And so that's important. Most people here would likely have seen something owned by a revocable living trust. Each revocable living trust is different, but as long as the person who set up that trust is the same person that is selling it, then they have full authority to sell that. Now, the Matthew Matrisciano Revocable Living Trust, if I die, it's still called the Matthew Matrisciano Revocable Living Trust, but after my death, it actually becomes irrevocable. So you have to watch and kind of be aware of who the trustee is. An irrevocable trust also avoids probate for any assets that are owned by that trust. And there are many reasons to create an irrevocable trust. Oregon has the state tax for any anything over $1 million is going to be subject generally to Oregon's estate tax. And so sometimes irrevocable trust can be created to mitigate that. So those are just kind of some things to be aware of, some things you might see. And with an irrevocable trust, it's very important to know who the trustee is, how many signatures are required, that sort of thing. Let's talk a little bit about, oh, actually, before we move on, Arianna, do you want to chime in about this at all?
Yes, thanks, Matthew. I just wanted to make a mention that vesting and trust is quite an in-depth topic all on itself. So we are putting together a class that will specifically be directed and geared towards trust and vesting for real property down the road. So if we can restrict questions for any vesting questions or any trust questions, again, that will be down the road coming soon, or private counsel with Matthew. That will be great. Side note on there, anybody who has worked with me in the past on the buyer side does know that vesting, I make sure buyers are always receiving a vesting worksheet at the time of open escrow. So I highly encourage all agents out there, when you have buyers in a transaction, make sure that you are kind of keeping tabs to make sure that your buyers, if there's more than one buyer, or if they know they want to vest in a trust, to make sure that there's communication happening with the escrow officer and your buyer so that proper vesting happens at the time of close. The amount of times I've seen transactions go south simply because of the fact that vesting wasn't done properly when they purchased, it does happen quite a bit. So I think vesting is one of those areas in escrow that for some reason is not really focused on and is so imperative. But again, vesting and trust, that's a class that's coming soon. So Matthew and I will talk more on that later. If you'd like more information, of course, you can always reach out to myself or Matthew after this class.
Okay. So then next, let's talk about probate. That's why we're here. And it seems like most classes, in order to talk about the reason you're there, needs to talk about other things first, like we're here for probate, but here's all the probate alternatives. Now we're getting to the meat and potatoes of probate. And there's a lot of bad rap that probate gets, and I think for good reason, but there are some reasons why probate is a good thing. If someone has no one in their family that they can trust, then the court will generally have some oversight over individuals that you may not trust. Or if there's no will, then there's no proof of trust that the deceased person had. And so the court, again, still requires oversight of that, but it is limited. It's more like if anybody complains, then we'll look into it further. There are definitely a lot of court requirements that you have to go through, and notification requirements that kind of helps that oversight. There's also newspaper publication that has to go out, and other ways that you need to inform creditors and potential creditors, which means that a probate is a good way of cutting off creditors. If you don't know what's out there, you're worried, you don't want to be looking over your shoulder after mom and dad die, that there might be creditors coming out of the woodwork years down the road. So that can be a positive thing. The negative pieces, the cons, probate is public record. So what you owned when you died and who it goes to, as well as their address, all is public record. And so there are definitely people who peruse the public record looking for somebody who just got a big inheritance to scam, and it happens. So that in itself, to me, is a big reason to avoid probate. The cost of probate I would say that Deschutes County is the most expensive county that I've experienced in Oregon, mostly because of the newspaper publication. Ben Bolton has a bit of a monopoly on that, but that just is what it is. And the cost to file in court, the court filing fee and the newspaper fee, is that in itself is approaching $2,000 just to get started before you even pay for any attorney, or pay for a mover, pay for anything else. And so it can be expensive. And so by the time you're all said and done, there's definitely it can be $6,000 to $12,000 on something that seems basic on its face. Before we leave this slide, I want to talk about just the process in general. I don't have a slide for this, but they would file probate, they would get approval from the court to be in charge of the probate. That's called, they would be the personal representative. That's the person in charge of the probate. And then that person would be would have authority to act on behalf of the estate for assets, collect assets, sell assets, and they can do an awful lot. But there are exceptions that we'll dig into a little bit here. So now you've been hired by the personal representative. They say they want to sell a house. Well, what should I know? Well, what gives them the authority to act on behalf of the estate? If there's a will, it's called the letters testamentary. If there's no will, it's called the letters of administration. And it's not an official like letter, dear so-and-so. It is a court signed document signed by the probate administrator, allowing the personal representative to act on behalf of the estate. And while usually they have the authority to sell the property, the letters might mention a restriction on the property, and that restriction means you need a court order to sell any real estate or anything mentioned in the letters. And so this is one of those exceptions you need to be aware of if you are kind of on that end of selling it. If there's more than one personal representative, which I try to avoid, but it does happen, how many signatures are needed to sign? Sometimes it's one out of both. They both have full authority to act independently, but does it instead need both signatures to act at all? They have to agree and both sign. So again, it doesn't happen often to have more than one personal representative, but just be aware of that. And a personal representative is the one with the authority. They cannot give that authority away through a power of attorney for real estate. So they might be able to delegate to somebody to say, well, go get some paint from the supply store and I'll reimburse you, and act on that in that way on behalf of the estate. But to sign a real estate contract, it needs to be the actual personal representative. So you're putting a house for sale. It's in an estate. What would the attorney want to be aware of? Well, some attorneys differ on this. I would say at a minimum, they would want to be informed when the house is put up for sale. They want to see the contract to make sure that the parties are mentioned properly. and approve the deed before it is signed. And then after the transaction to see and get a copy of the closing statement. Now the contract itself and the deed need to list out not the name of the deceased and not the name of the personal representative. Instead, it's Arianna Lease, personal representative for the estate of Matthew Matrisciano. And that would be at a minimum kind of the proper way of doing it. Arianna Lease, the duly appointed and acting representative for the estate of Matthew Matrisciano. There's any of those would work as long as it's not listing either the personal representative or the deceased person individually. Arianna, I had these two slides here. I kind of skipped that last one. Do you want to add anything at this point?
Yes, I was just going to bring up what happens if a seller passes away in the midst of a transaction, and due to lack of vesting, it is going to be a forced probate in order to get the transaction closed. So it can happen, and we can get probate opened and ready to go so that we can close the transaction. Matthew and I have actually teamed up on quite a few transactions where that unfortunately has happened, and we've had to get probate going immediately, and he deals with the courts, we get the personal representative appointed, and we can get the transaction closed. So it can work. Timing, though, is of course of the essence. Matthew, do you mind giving a couple of examples that we've had, and we're currently in one, where Matthew and I he's gone to probate push through literally within 10 days. And then other times, due to heirs being all over the country, different locations, it can take a little bit longer. So what's kind of, Matthew, the fastest you've seen a probate get pushed through and the longest sometimes you've seen it take?
Yeah, so if someone came to me and as this happened and says, I have this piece of property, it is in escrow, but the person passed away, I would need to get a copy of any will, a death certificate, get all the information that I need in order to create a document to get the personal representative appointed, get the signatures, and then get that filed in court. Then we wait on the court, and that's a big unknown these days. Probate in some counties is moving faster because it's done without any, just done after hours even. I had, a judge sign something at 7 in the morning or 6 at night because, the court doesn't have to be open. They can just deal with it whenever they want. They just need to make sure all the paperwork is in order. But I've had other counties where it's not a priority because it's not in their face. They don't have a hearing coming up. And so that is difficult, but once the paperwork is filed, it can be a couple of days, and then it's just getting that paperwork filed. Some people say they have a will and everything's in order, and it's not. The court needs proof of the will, so that sometimes we need an additional notarized signature of the witnesses, or a testimony of the witnesses who signed the will, even if it was years ago. I had one where the people passed away, and then we had to get somebody else to verify the signature on the will. And there are lots of different things that can take time. And so getting all that done is very dependent on, how long does it take for me to get that information out and get it back from the people who I need signatures on. So there's a huge variation, but it can be fast if everything is simple in that initial phase of either there's no will, period, there's no argument about it, or 2, there is a will, but everything's in order, it's ready to move forward. So I've had some that it takes 60 days just because you have to get somebody else's approval, and they are busy, they are forgetful, and so when you rely on multiple other people, then that timeline kind of has to be pushed out in terms of an expectation. Then hopefully you get it done sooner. But if everything's in order, you can get into the court, and at that point you just wait on the court, and it can happen in 10 days. So that's sort of the complicated answer of how long does that take. Arianna, did I answer that enough for you? Okay. All right, I'm going to share my screen again and move on to the next slide. Just chime in if you want to add something else.
Matthew, and I think this would be good if you answered this question, because I think just to clear up any questions on what a probate is. Somebody's asked the question, are the rules the same if a buyer dies mid-transaction? So obviously the buyer doesn't own the property, so there wouldn't be probate, but do you have anything to add on to that?
Yeah, it's getting the authority to close that transaction. And I would say that it's not a done deal until it closes. And so if a buyer dies in the middle, you would still need probate or probate alternative. So while it's not exactly the same, I think it's close enough you could treat it the same on your end, yeah. So let's talk about one of the alternatives, which is the small estate probate. A small estate, like I said, the real estate has to be worth less than $200,000. And unlike a probate, which has a personal representative who's appointed, and that person has authority to do practically anything unless there's a restriction. And then basically in a full probate, it's okay for you to fix up the property, wait 6 months, and then sell the property, and kind of take your time. Small estate probate, once you file that small estate affidavit, in exactly 4 months, legally the vesting switches. And that, unless somebody complains in court or files a full probate and converts a small estate to a full probate. And that adds a lot of complication in trying to sell a house. And even for small estates, sometimes I recommend going with a full probate just to avoid that complication. So after 4 months, the real estate listed will belong to the heirs and beneficiaries. And there's no official personal representative. It's called the affiant, the person filing the affidavit. If you find a buyer and sell after that 4-month period, the affiant doesn't have control anymore. It is their duty to distribute it to the heirs or the persons listed in the will, and then the heirs would be both they would be the seller from scratch. And even if there's no deed yet, then that should happen. It should file a deed to the heirs, and the heirs would sell the house. They would sign both the contract and the deed to the new buyer. If you sell the house during that 4-month period, the affiant can sign the contract, and as long as closing is during that 4-month period, then that will still work. But the heirs and beneficiaries, people who are entitled to that property, still need to sign the deed. And Arianna can talk about what the title requirement is there. But that is a very different situation, adds a lot of complication. I had a small estate probate with 17 beneficiaries listed in the will. All 17 would have had to sign the deed during that sale. So just the logistics of it make no sense. Going with a full probate avoids that. All you need is the signature of the personal representative. So that is a huge difference and cause small estates can cause a big problem in that sense. For example, if the contract is signed to sell the house during the 4-month period, but closing has to occur after that 4-month period is over, it's the same as someone dying in the middle of it. The owner has technically changed. Only instead of from the individual to the estate, now it's from the estate to the heirs. And so in that situation, if you know that's going to happen, but you need to sell the house and you need to keep it in a small estate, have all the heirs and the affiant sign everything from the beginning, and just know that that's how it's going to end up. You could probably still move forward with it, but you need the approval of title. And Arianna, why don't you speak to sort of the oddities that you've seen there and what to expect?
Thank you, Matthew. So going back to item 3, selling and closing escrow during the 4 months, quick mention on that. The estate will have to obtain an EIN tax ID number, okay? Because we will 1099 the estate itself if we close during that 4 months. The flip side of that is if we close after the 4 months, then we actually 1099 the heirs, okay, as individuals. So just a quick side note on that. What I have also seen is what I'm currently involved in a transaction that's a small estate. It was actually, it looks like it was a full probate down in California, but then they had a little piece of property up here in Oregon to which the heirs went ahead and just did a small estate directly with the county here. There were quite a few federal tax liens against the estate that were released with the, well, they were taken care of through the probate in California. And the federal government, the IRS, went ahead and cleared off all the liens, except what happened is the IRS did not provide the proper documentation that a title insurance company needs in order to show that those liens were actually released in the county that, in this case, the property is located in, which is Deschutes County. So what we have now is we've got the 4 months have passed, but we've got huge IRS tax liens that are still showing outstanding, even though they have technically been cleared by the IRS. We still need documentation to be recorded with the county from the IRS to show that they have actually been cleared and passed through. So we were able to get everything done, but now we're waiting on the IRS. So again, I think that's why it's so important too, that I know a lot of people like to try to do things on their own and try to save money here, there, or everywhere. But a lot of the times trying to save money or cut corners eventually can cause a little bit of a lag or hold up in the escrow at the end of the day if it's not done correctly or you're not following the guidance of an attorney.
Sure, yeah, and I definitely second that. I've had even, well, whether it's small estate or full probates, people come to me mid-probate and it's more expensive often to unwind the mistakes than to just have done right the first time. All right. So I wanted to try and give you some ammunition in your quiver, arrows in your quiver, I guess would be more appropriate. So you can ask your client the right questions to help them get the best advice possible, make you look good ultimately. So one is get to know more about the deceased. In a situation where the person lived and died in California or a different community property state, every state that touches Oregon is a community property state, but not Oregon, as well as a few others. And so what's important there is, without getting into detail because it's a complicated tax issue, is if one spouse dies and the other spouse is alive and then they sell something that has capital gains, it is better to recognize that as community property than as Oregon's joint property. It can eliminate, under the current rules, any capital gains if it's community property. And so it's really important just to say, do they live in a state that's community property? If they do, inform the CPA. There's something about capital gains going on there. You know, you don't need to be the expert, but it's helpful just to ask the right questions, and to say, this is something you need to talk to an attorney or a CPA about, because there's something about the fact that this property in Oregon was community property because the person either owned it as community property before they moved here, or they currently lived in a community property state when they died. And that's most important when there's a surviving spouse. But again, that's not, I'm trying not to make it your job to know everything about tax and law, just to kind of ask the right questions. I do recommend that every person selling a property after death talk to an attorney about whether probate needs to be opened. I've had a client come in after somebody died. They went to sell the house. The realtor marketed the house. They put it under contract, and then halfway through realized that they needed to probate to sell it. But that was true before they even contacted the realtor. And so the realtor should at least know that if someone has died, the owner has died, that a probate is likely necessary, and to go talk to a professional about, let's get that started, you know. So the moment that you enter into a contract to sell the home, it's in probate, and the closing date does not need to change. If you try to start a probate after there's already a contract, there's no guarantee that you can close it in time. And so it just needs to be really carefully done. The other piece is, should you sell a house in a probate as is? Should you do improvements? I've seen a lot of probates where maybe there's a joint bank account. So the bank account goes to the surviving owner. And so the estate itself, the probate, actually has no cash. Or the person is just maybe on Medicaid or otherwise just doesn't have a lot of cash. So while it might make sense to say, you know what, we could put $10,000 into this house and it would sell for $50,000 more. That might make financial sense, but I've also seen it really ruin people's lives for a few years when they spend their own personal money on making improvements to probate property. is it better just for peace of mind for your client to sell a property as is? You know, we're talking about the probate process here, the financial piece of it, the legal piece of it, but there's definitely a personal piece to it. You can't forget about, you know, what they're going through, the fact that they have their own lives, their own jobs. Now, in addition to that, they have to step into a probate. It's almost like running a business, and it's a lot of work. And so for them to step in, not only to just manage a probate, but also manage, you know, home improvements and how do you pay for those. If they start talking about repairs, talk to them about where that money is coming from, and that it's not going to put them in a bad spot financially. Because there will be other costs of the probate. So if the probate has $10,000 to its name, then don't spend 8 of that on home improvements. That's, you know, you're going to still end up likely in a situation where at some point the personal representative is going to need either a loan from family or just pay out of pocket until the house sells. And I generally try and avoid that because I've seen it not turn out well, even when they're paid back fully for the loan. You know, it can be a strain on them personally, financially. This gets into a little bit more of the legal side, but because it's not likely to get a copy of the will, but it can complicate things if the will says that my piece of property at 123 Wall Street, Bend, Oregon, goes to, you know, my daughter Arianna Lease. If it says that, and the personal representative who's not Arianna tries to sell it, then then it could be complicated, and you need to get some counsel on whether that's allowed or not, and perhaps just, you know, come up with a consent that Arianna, or, you know, would sign saying, I know this house goes to me, but it's okay, you can sell it in the probate. So that can complicate things too. And in general, you know, would there be an heir or beneficiary interested in buying the property? And does that make sense? That's, you know, it's important for the personal representative. They have a duty to do what's best for the probate to bring in fair market value. Fair market value is a range, but it's also possible to sell it at under fair market value as long as basically no one cares. All of the heirs have signed off on it, saying, you know, that I understand that I could have gotten more money from an inheritance, but this is fine. Things like that can happen and can sometimes be a benefit to the family as a whole. But you know, those are, again, just questions that add value to your client. Just try and get more understanding of the deceased and the family and the property, so that you have an understanding. One thing I didn't write down here, but I mentioned briefly, was if the deceased was on Medicaid, not Medicare, which is insurance, where they pay a premium, but Medicaid, where the state would pay for long-term care, in-home assistance, things, you know, help with daily activities, then the state of Oregon would expect to be reimbursed from that, would probably put a lien against the property and be paid back in that manner. And so that's something important to consider. With the way real estate is now, it's not likely that it's going to take up all of the equity in the home, but it certainly could, depending on the loans and value of the home. So all things to think about, and just ask some questions about so that you can move on to the next step of, well, what does that mean? Arianna, any?
A couple add-ons in terms of Medicaid and with the state of Oregon. From a title insurance standpoint, on all probates or small estate affidavits, there will be exceptions in the title report that show that escrow should be reaching out to, we refer to it as DHS, that's with the state of Oregon, to confirm that Medicaid is not owed. If DHS gets back to us and states that Medicaid is owed, we will pay that through escrow from the estate proceeds. And then Matthew, 2 questions came up that I think are a little bit in line with that slide, just before you move on to the next one. If you don't mind me interjecting and asking these 2. Does having a trust in place instead of a will simplify a real estate transaction process? And of course, I can answer that from a title insurance standpoint, but from an estate attorney standpoint, do you want to answer that?
The answer is yes. Having property owned in a revocable or in a trust means that the trustee has the authority to act according to the trust, which they pretty much all allow the person to sell that property. And so the trustee would just be allowed to step in and sell it. There'd be no appearance in court, no court approval required. What you need is proof of who the trustee is, and then just a proof of identity to prove that the trustee is who they say they are. And that seems to be pretty much all you need. And then they can sell it. There's provide a copy of the trust generally, or a trust certification, which is my preference. And the trust certification will provide all the information the title company or other financial institutions would need to know without all the personal information about exactly where you're leaving your assets and that sort of thing.
And then the next question is, what if someone had a will with several beneficiaries on a property, but the will appoints someone specifically to manage the sale of the home? Would all beneficiaries still need to sign, or just the person appointed?
The personal representative is the only person in a probate that needs to approve a real estate transaction. And so the reality is the heirs can say, no, don't sell it, don't sell it. And in most situations, they can sell it anyways. Sometimes it's the only fair way to divide things. If one heir lives in Oregon and 3 heirs live in Florida, and then there's a piece of real estate in Oregon and you want all 4 of them to own it, well, that's going to not be fair to the 3 heirs in Florida because they don't live here. It's just going to be all for that one person, even though they only own a 1/4 interest in it. Probably makes more sense to just sell it, divide the proceeds. But it can be case by case, but that's a general information.
More question for you, and then we can move on. What is the deadline to file a claim against an estate?
4 months after the newspaper publication or the notice to heirs, whichever is later. And there are exceptions to that as well. If you intentionally avoid a creditor or there's a known creditor that you just don't notify, there's still a bit of a fiduciary duty to creditors, and so that needs to be taken into account. But it's 4 months. So I'm moving slower than I thought I was going to, so I'm going to jump through a couple of other things here. We have transfer on death deeds. This automatically transfers to the beneficiary listed on the transfer on death deed. So, but it has to be a named person, meaning that if you say on the transfer on death deed, upon my death, it transfers to my children, you didn't name anybody. There's no name, and so it doesn't transfer to anybody. If 3 children are named and 1 dies, then the other 2 receive it, not the deceased child's heirs. So a transfer on death deed, I generally try and steer away from. Creditors, unlike a probate where they have 4 months, like we were just talking about, they have 18 months to attach a lien onto the house through a probate-like proceeding because there's no notice, because there's no newspaper publication. And they have that 18-month period. And so during that 18-month period, it is, I think Arianna would say impossible, and I would say next to impossible to actually sell that house during the 18-month period, because there's a cloud on the title. You have to allow that time for creditors. And so if you sell the house to somebody, who's to say a creditor can't attach a lien on it to the buyer? Who would do that? You know, probably nobody. So there's a very, very limited situation where it's good, but even in that situation, you're taking a risk. So that's that. Joint with right of survivorship. Tenants by the entirety is only allowed for a husband and wife or spouses. And I say husband and wife, but it is spouses. So so I apologize for that slip, but you know, wife and wife, husband and husband, whatever it is. And so no probate is needed at the first death because it passes automatically to the surviving spouse. Joint tenants with rights of survivorship. The best phrase to use is not as tenants in common, but with rights of survivorship. That is really important to have that in there. And similarly with tenants by the entirety, no probate is needed at the first death, but it does not have to be between spouses. Tenants in common means that each person, this is kind of the default here. So if you're not sure, if it's not clearly tenants by the entirety or rights of survivorship, it could end up in tenants in common. And in that case, the deceased person's half would have to be probated. Generally not the case for spouses, but generally the case for everybody else. Arianna, I think you wanted to touch on the rights of the joint tenancy here.
Yeah, I was going to make one mention. I see quite a few times when sales come across my desk that there is no vesting at all on the existing deed. Just so you all know, and this is again from a title insurance standpoint, if there is no vesting, it is assumed that it is tenants in common, which can be obviously very dangerous from a title insurance standpoint if God forbid something happens to somebody. That's why I will reiterate again, the importance of when people are purchasing real property, vesting is absolutely imperative. So again, if there is no vesting and there's more than one person on title, we will be under the assumption that it is intended as tenants in common. So that, again, from a title insurance standpoint, Matthew, if you want to add anything onto that.
No, I think that's good. So let's, you're all right, we'll kind of move on to the last little bit here. Other questions to ask your clients might include, why are you selling your home? And this is not in probate, this is kind of a general thing. If they're selling their home because of long-term care, you know, I need to sell my home because I can't afford the in-home, you know, I need to go into an assisted living facility. I need to go into memory care. They need to see a long-term care planning attorney before they do that, because there might be better ways of kind of planning for that Whether it's selling the home and doing something with the proceeds, or it's don't sell the home, you could still qualify for Medicaid to help you with long-term care. There's just it's a very, very complicated area of law. And there are some long-term care planning attorneys in Central Oregon, including myself, that it's really a specialized area. If you just have a revocable living trust and they're buying a property coming from California or Texas or wherever, ask if they have a living trust already, because chances are they're going to want their new home here in Bend or wherever to be placed into that trust. Again, if just having a trust is not good enough, it only has control of the things that are owned by it. So you, whether it's during the purchase process or directly afterwards, they're going to want to transfer that to their trust likely. If they do not have a revocable living trust, most people can benefit from having one because of the probate issues that we just talked about. Having a will does not avoid probate. It just tells the probate court what you want. So a will is better than nothing. And for most people, not everybody, but for most people, I recommend a living trust just for the simplicity issue and to ease the transition to your heirs. Again, kind of what we talked about before, that the trustee of, in this case, the John Lennon and Yoko Ono Revocable Living Trust, it may not be John or Yoko, it might be Paul McCartney. So because John Lennon and Yoko Ono may have passed away. So just because it has the word Revocable Living Trust in the title of the trust doesn't mean it's still revocable. Just be aware that the people who created the trust are also the people who are signing. The trustee of an irrevocable trust could be the people who created the trust, or it might not be. In other words, know who the trustee is, who has authority to act to sell that home. I do have some examples here really quick. If real estate is owned as tenants by the entirety with wife, the wife now owns it because, look at the top here, the husband has died with a surviving wife and a child from a previous marriage. The wife now owns it automatically because they owned it as tenants by the entirety. There is number two, if real estate is owned only in husband's name, a probate is needed. And if there's no will, the surviving spouse will probably end up with only half, because if there was a child from a previous marriage. That's what's required if you don't put estate planning together. If you don't have a will stating what you want, at least, or a trust, or some other means of getting the asset where you want it. When there's second marriages, things often end up going to places you don't expect. Number three, real estate is owned as tenants in common with the child from a previous marriage. Well, the child from a previous marriage continues to own their half, and then the husband's half requires probate. And kind of the same thing would happen there. A couple of other non-real estate examples. There's a joint bank account with husband and his caretaker. Well, it doesn't go to the wife, it goes to the caretaker. Now, in some instances, there's ways of avoiding that, but that would be sort of the automatic thing that the bank would allow. And you got to be careful, if there's a caretaker involved, maybe ask some questions about that with your client as well. Life insurance with no beneficiary listed, it might require a probate. So it's just kind of a quick run through of how messy things can get. I don't want to get into it too much because I have taken too long to talk. Arianna, why don't you add anything that you want and see if and it's already 11, we have plenty of time for questions.
One thing I'm going to add just in terms of trust, if you have a transaction and our seller is the successor trustee of the trust, which Matthew was referring to, that Yoko Ono and John Lennon Trust, Paul McCartney ends up being the successor trustee because they've both passed. Please prep your seller for understanding that most likely title will need a full copy of the trust and any amendments. We do this to confirm that the successor trustee truly has the authority to act on behalf of the trust in that capacity, and that there potentially isn't somebody else, another heir beneficiary named in the trust as successor or an additional successor. And I have seen that sometimes you have both children acting as successors of the trust, as opposed to just one or maybe even three. Matthew, really fast, I want to, because I was mentioning the successor trustee question statement. What if the property is owned by a trust, 3 siblings are successor trustees? What if one sibling does not agree to the sale of the property?
You first look at the trust document. How the trust will hopefully say how many people have to agree. Sometimes it's only one has the authority to sign. In that situation, you get some messy because it's a messy situation, because one person can sell the house, the other 2 people are saying no. It can sometimes be best in that situation to get either everyone to agree, which sometimes is impossible, or it forces itself into court for a court to determine that. Sometimes trust will lay out how are ties broken. If everyone can't agree, then is one person in charge of making that decision? Is there a 4th person who's in charge of making that decision? Or does it require mediation or arbitration instead of going to court? You go to the trust, and the trust will tell you, hopefully clearly, how that is decided. If it doesn't tell you how it's decided, then you need to look at the statute, and that's too much to get into today.
Thank you.
Yeah.
Hannah, do you want to take over with, there you are.
Yes, there's a few more questions in the Q&A box. I've always heard that you should seek to avoid probate if possible. Matthew, do you recommend anyone with property and/or assets creates a living trust, or does it depend on the value or complexity of the estate?
So I think that a vast majority of people should probably have a living trust just because of the ease of transition. The people that I don't recommend a living trust for are people who, because of their personality or because of their health concerns near the end of life, cannot follow through with putting their property in the name of the trust. I had a client in his 30s and his wife, and they're like, I'm not going to do that. That's way too much trouble. And they had millions of dollars, but there's no point in having a revocable living trust if your property moves around so much and you can't keep track of it and don't care to create that living trust. So there are people that it doesn't work for because they're going to end up in probate anyway when they sell one rental, buy another rental, and now it's still out of the trust. And so in that situation, it doesn't make sense for everybody. And like I said, creditors can be cut off more easily in probate. So sometimes it makes sense to have a small probate for risky professions, like professionals, dentists and lawyers and doctors and things like that. to increase the potential of cutting off future creditors.
Okay, thank you.
But a living trust, even then, can suit them well to make sure a majority of it avoids probate and avoids public record.
Perfect. Next question. If in a trust, do they still have to sell? And what if there are deferred property taxes?
It doesn't make sense to me most of the time to, when I'm creating a trust, to require someone to sell, because the future is very unknown. I mean, look at the last 2 years, look at the last 5 years, and I like to give them the option to sell. I think that makes more sense, and to give the trustee discretion to do what they feel is appropriate.
Okay. If someone had a debt against their home, can they change the vesting to a trust?
Yes. A revocable living trust is considered to be owned by the individual for for creditor purposes and tax purposes. So Garn St. Germain is the law saying that a creditor, like a mortgage, cannot call the loan because you put it in a revocable living trust. It does not trigger that due on sale or due on transfer provision. It's still considered owned by the people transferring it to their own revocable living trust. And it's going to be same for the deferred taxes that was mentioned in the last question.
Okay. And back to the situation with the 3 siblings, would the executor in charge be the mediator?
That's really specific. If there is one executor, then you need to look at the document, but if the executor, which in Oregon is called the personal representative, they would probably just have the authority to do what they want, and not even, not necessarily mediate, but just sort of do what they feel is best. That's ignoring, of course, feelings and trying to keep the family dynamics together, keep the family unit together as a whole as much as possible. But that's probably, again, you need to look at the situation and look at the document.
And is there a ballpark cost of creating a revocable trust?
Not really. It depends on the number of different assets that you need to go into it. It depends on whether tax planning is recommended. It depends on whether you expect retirement accounts to end up funneling through the trust, and whether special needs are going to be included in a living trust. It really depends. I don't know about about other estate planners. I know that my office, I don't charge for an initial consultation because there's so many things that go into that. And I think there are some other offices that feel similarly, where let's have that conversation so that you're not afraid to call us, and then you walk out knowing what the cost is and what you're going to get for that.
Okay. And public notices, are they also online? Or are they just printed?
I think that depends on the newspaper, but I think the bulletin has an online. Yeah, has all that online. Pretty sure.
Okay. Well, that's all I have in the Q&A.
Okay. Well, thank you very much, and I'm glad I could help. And here's my contact and Arianna's contact again in case you need it. And I guess I gotta make these slides available if somebody wants them, and I'll send that to you, Hannah or Amy, and we'll get it done. So.
Well, thank you so much for your time to be here today and to put the presentation together. I think it was really, really helpful, and we had some great questions. So yes, we will email out the slide deck as well as the link to the recording by the end of the week, and you will also receive a CE certificate by the end of the week in your email. So Arianna and Matthew, thank you again, and thank you everyone for supporting Western Title and joining us today.
Great, thank you.
Have a good day.
Have a good day, bye.